Okay, it is finally week 10. Week 10. Week 10, everybody. Um, Introduction to criminal law. Fall quarter is about to end in another week or so. So today is our last lecture. So I wanted to make sure that you received information uh, to help you complete week 10 and direct you to week 11. I told you earlier that this quarter would go by pretty fast. So let's take a look um, at our, that's not what I want to share. Let's do, there we go. Okay. So as you can see, your assignments for the week, there's the rubric right there for week 10, and it tells you 2 to 3 pages in length. It tells you explain what plea bargaining is, and then it tells you to deal with these last 2 issues. Make sure your APA references are provided, and make sure that you run your papers through Grammarly. That's a written assignment. And then you get down to the course project, 2 to 3 pages in length, and it gives a specification too as well. Remember, APA requirements have to be satisfied. That means citations in the body and references in the end. And then finally down here, you see that this is our last lecture, week 10. I will provide a recording of this lecture as well for you. So let's take a look at our announcement for the week. Your Module 10, what to expect before and during trial, Chapter 17 and 18 of Criminal Law and Procedure, and then complete the activity pretrial and trial expectations, which we'll briefly go over in just a few minutes. And then your initial post due tonight, 11:59 p.m. Central Standard Time. You want to make sure that you get that done. And jury selection voir dire. I've had a few students to comment about it, but there is an issue that is involved with determining whether or not the person who alleges that their constitutional rights have been violated, and you will see the answer in one of my responses. But at any rate, make sure you get that done, and then Saturday night, 11:59 p.m. Central Standard Time, your reply post. Plea bargaining is your initial post. I just showed you your initial, rather your written assignment. I went over that a minute ago. You have a quiz, which I always recommend that you do at the end of the week, but some of you insist on doing it before that. And then your project filing pretrial motions. Make sure you satisfy all the requirements. We want you to finish strong, and I've already shared with you what adversity at springboard success is all about. So let's take a quick look at our course calendar. And there it is, generating. And it tells you where we are right now. We're at the point where this is the week that we're in right now. And then these are the assignments that are due by Sunday the 10th. And then next week, notice next week, the course ends at midnight or 11:59 p.m. on after the 15th. 11:59 p.m. the quarter ends. That's been in your calendar since the beginning, and it's also going to be in next week's announcements. So all of your assignments have to be in by that time. Okay? So now let's take a look at Module 10. Let's take a look again at the assignments. again, fact pattern given for plea bargains. It's 2 pages. 1 page won't do. A page and a half won't do. Page and 3/4 won't do. And answer these questions with the bullet points. And then your discussion posts dealing with Danny and his issue about alleging that his constitutional rights, the 14th Amendment, equal protection and due process rights. And then you're going to say, do you agree, why or why not? Explain. And then what factors must the court take into account when selecting a jury of your peers? So, again, make sure you follow the instructions I told you about that. And then your pretrial motion is also 2 to 3 pages. And you want to make sure that you get all of these done, especially these projects. Don't neglect, though, the written assignment for the projects, because you want to maximize. This is where you get 100 points. As I said earlier, weeks 8, 9, 10, and 11 for your projects, you can lose a total of 400 points, which can really blow you out of the water if you don't do well on those. So you want to make sure that you do well there. And then, of course, there's the quiz there. Okay, so let's go back to the lesson content for this week. Again, what to expect before and during trial, and we're gonna talk about that again. Those are your assignments, and then this tells you what pretrial motions are all about: motion dismiss, motion to suppress, physical evidence, motion to disclose a confidential informant. These are various motions. Plea bargaining that takes place, and then the right to a jury trial, and then you go through these little exercises. And so an arraignment. So what's an arraignment? And you flip it over. There it is. An appearance before a court of law for the purpose to answer a criminal charge. And you go to the next one. Pro se. You also can see it at the top. You don't have to flip it over. Person who represents themselves. And so I'm not going to go over all of these, but there are several. So you can take the time to go through those yourself. Okay? So with that in mind, I'm going to go ahead and go back into discussing the issues before us tonight. We're going to end promptly a little bit after 10 because we started about 5 minutes later. So the pretrial process. Now you should be aware of the fact, just letting you know up front, that the pretrial process is something that is pretty tedious, but is absolutely necessary. And you're going to discover that there's a lot of things that happen, and it takes a long time. For example, I had a number of criminal cases where it took at least a year, maybe longer, to go through the pretrial process because of the various motions that we had to file on behalf of our clients. One of the first motions that we would file immediately at the beginning of the case is a motion for discovery, or in some jurisdictions, disclosure, where we ask for all of the evidence that the prosecution has against our client to substantiate the charges that they're bringing against our client. And then there are many other motions which we'll talk about. But be aware of the fact that the motion for discovery can extend out a long time, because a lawyer who defends an individual generally does not want to go to trial, or either try to push trial without having all of the evidence that is necessary in order to prepare an adequate defense for their client. So the pretrial process, and it means what it says, this is before trial, if there is a trial, and you'll know why I say that in just a few minutes. So in the trial, where you have a right to receive notice of the charges, that's what happens at the arraignment. Then you have an adequate opportunity to contest the charge. Again, starts with discovery and receiving the evidence, and then also the motions that are filed after. So the steps go like this. Your initial appearance is filed and started. There may be a preliminary hearing to determine whether or not there's adequate evidence or there's a finding of probable cause to, not that the person is guilty, but there is sufficient evidence that a judge might determine to be able to take the case to trial. Then there is also some process, sometimes we're bypassing this, the grand jury proceedings, where the grand jury listens to the evidence that the prosecution alone presents. And when I say that, there's no defense attorney there, the defendant is not there, but that all of the evidence that the jurisdiction or the prosecution has to proceed with the case is presented, and then the grand jury decides to vote what we call a true bill. That is based on a majority of the grand jury, and once that is determined, then the individual is bound over for trial. And then at that point, then there is, then you have the arraignment. At the arraignment, you only do two things. If you ever saw the movie My Cousin Vinny, at the beginning, at the arraignment, the judge admonished the attorney that he was only there for two purposes, not to present evidence or to dismiss the case, but to answer either how do you plead. So the answer is either guilty or not guilty. It's not both. It's not a little bit of each. It's one or the other. So the key thing is that that's what happens in the arraignment. Each individual has a right to counsel, and under the famous Gideon versus Wainwright case, which says that a person who couldn't afford an attorney could be provided at public expense, and this applies to federal as well as state cases as well, and includes charges such as even treason, felony, and in misdemeanor cases, and is allowed in most states. Of course, I don't know of any. I know Illinois does allow for the right to counsel. Like I said, the old Gideon versus Wainwright case, and then there's a great movie that if you ever get a chance to look at it, I have the movie right here in my hand, and Henry Fonda plays in it, and it's a very good movie. It's about 104 minutes, and it's very, very good about explaining the process that took place as to why the law was changed on a constitutional basis to require that you have a right to counsel. And here we are talking about Gideon versus Wainwright. 51-year-old indigent drifter requests a lawyer. The judge said no. The Supreme Court stated that the right of one charged with a crime to counsel, one who charged with the right to a crime to counsel, may not be deemed fundamental and essential to fair trials in some countries, but it is in ours. So it is something essential that individuals have a right to, since the foundational case of Gideon versus Wainwright of 1963 case. There's also a very good book about Gideon's Trumpet, which is a story about the case itself. And then in 1979, the Supreme Court ruled that no indigent and defendant can be sentenced to a prison term without providing counsel. The court also held that the counsel is not required to be provided if the defendant is not receiving a prison term. Scott was convicted of shoplifting and fined $50. He denied counsel, but was denied. He asked for counsel, but was denied. So if you're going to face prison term, then you absolutely have a right, as clarified in 1979. Again, in a case Strickland versus Washington, the Supreme Court held that a defendant has a right to effective counsel. Effective counsel means that the counsel must be one who is prepared, one that is able to defend the individual, not sleepy in court, not drunk, doesn't come to court ill prepared, and is not incompetent. For example, not every lawyer can defend an individual in a criminal case. There are some lawyers that handle corporate or real estate or estate matters, but not criminal cases. So the defendant has a right to a competent attorney, one who is familiar with the rules and the laws that are involved with criminal cases. And essentially, in death penalty cases, effective counsel is important. Makes sense because of the fact that an individual's death or life is at stake there, and there are also many, many, many steps that take place. So there is an absolute right in all cases for competent attorneys. Petty offenses, which citations issued such as like traffic court or other violations, some of those you don't have an attorney. You have to get your own attorney, but you're not guaranteed an attorney. Laws pertaining to or requiring police officers to issue citations instead of making arrests, these don't necessarily require that you have to have an attorney. However, I do recommend that you do. One of the first things that takes place whenever a person is arrested and charged is to set what we call bail, to determine that that person is released pending trial. So what happens is that in those situations, charges are read, the person is informed about their rights, pretrial release or detention, which means the pretrial release involves that you could be released by what we call personal recognizance or what we call an I bond. Letter I is involved, but what it means is that probably the charge was not very serious, you probably were not a repeat offender, and therefore, and you had some roots in the area or community and that you weren't a flight risk. You could be released to the custody of another. That often happens in juvenile cases. And then bond is posted. Bond is generally, in our jurisdiction, 10%. So if you have a $100,000 bond that's issued by the judge, you have to post a minimum of $10,000 cash and or property to that value. Some people will actually place a lien against their real estate, their personal homes and stuff like that. So titles to their cars, all kinds of things. Bail can be excessive, but it should not be. The purpose for bail is to have a proper bail that guarantees your appearance. And the bail should not be based upon anything except that you will appear, and it could be higher if the charges are more severe. So you can be held with no bail in some situations. We're going to talk about that in now. Not here, the next one, I think. The Supreme Court held that setting bail higher than necessary to assure the appearance is excessive under the 8th Amendment, not the 8th Amendment. What happened is this person was charged with subversive activities. Bail was set from $2,500 to $100,000, but later all set for $50,000. The defendant moved to have the bail reduced, but the Supreme Court said $50,000 was excessive for this kind of case. Now, here's an example here where the Supreme Court held that there is no constitutional right to bail under the 8th Amendment. Remember, you have to have bail should not be excessive if it's granted. This instance here involved the mob. Salerno was denied bail because he was a member of this crime family and a threat to the community, which tends to create problems as far as you getting bail is concerned. The idea of bail is that you'll behave, you'll obey the law while you're out, while you're awaiting trial, you'll show up for court, and those kinds of things. So Salerno appealed, saying that it was unconstitutional to punish him for any possible future things that he might do. Well, the court says, no, 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 you're a known threat to the community, and so therefore it is constitutional for us to deny bail. And that happens quite frequently. It also happens frequently in capital cases that involve murder as well, or an excessive or either high bail, like $1 million. You know what happens in $1 billion? The person has to post at least $100,000, and that wouldn't really benefit in a mafia situation, because that would be no big deal. So that's why the no bail. So formal charges come about, and there are things that you are given to help you prepare, such as you have the subpoenas. Subpoenas are documents that are served on individuals to be witnesses in a case. There's also a document which is not mentioned here called a subpoena ducis tecum. That generally applies when there's some documents involved. Let's say, for example, if there is some kind of criminal case involving bank fraud or credit card fraud, or either bank using checks and things like that, then the documents that are related to the charges would probably come, but not just a subpoena. Subpoena means for the individual person, but the subpoena ducis tecum means not only the person shows, but they bring documents as well. Commonly it's used in civil cases, but it is used in criminal cases as well. Prosecutors have a lot of discretion to determine what the charges are that go against that are issued to an individual. And generally what the prosecution tries to do is bring charges that they believe that they can meet the burden. They don't just bring charges off the top of their head. And prosecutors are immunized from damages when they deprive individuals of their constitutional rights. Let's say, charging the person improperly or wrong, you can't come back and sue the prosecutors. Now, if there's some fraud involved, then there might be some problems involved. But short of something like that, then the prosecutors are immune from any repercussions. Documents can be charged information, which information determines whether the adequate evidence is sufficient or not, and that's a formal charge that's brought against an individual. And then I already talked about the preliminary hearing. We as defense attorneys like the preliminary hearing over the grand jury because of what I stated earlier. The defense attorneys are not allowed to be at the grand jury, but at the preliminary hearing, it's kind of like an opportunity for a mini trial to see if the case can be dismissed at that level rather than go through the full trial itself. In the United States versus Armstrong, the Supreme Court said that to establish prosecutorial discrimination, saying that they would charge a person on the basis of race, the defendant would have to prove that others in the same group were not prosecuted, or different races. It's a pretty difficult burden to meet. Armstrong claimed that he had been discriminated because he was African American using crack cocaine, but he couldn't prove that whites had not been prosecuted. If there is one white charged, then his case is out of the water, and it's not used very often there. The grand jury, I already talked about that. Remember I said a majority must agree. Potential jurors may not be excluded from the grand jury or the jury based on race or gender. And it acts as a shield and a sword, basically providing the evidence in secret, and then also determining whether or not there's enough evidence between what the prosecution charges and what they can possibly prove in a trial. So the prosecutor presents case and evidence. Witnesses are protected by the Fifth Amendment, which means they don't have to testify. Witnesses do not have the right to counsel, and then an indictment is issued if a true bill is voted. In the United States versus Calandra, not one of my favorite cases, the Supreme Court held that witnesses may not refuse to testify in front of the grand jury based on the argument that the evidence was illegally obtained. So what happens with Calandra? Calandra basically stands for the proposition that there is some evidence that is illegally seized could still be used to determine whether or not there's enough evidence to bring charges. Calandra was called in front of the grand jury to testify about loan sharking. The police had evidence that they had found his apartment. He pleaded the fifth, as I said he could, moved to suppress the evidence, stating that the evidence was obtained illegally. The court said no, that the exclusionary rule does not apply in grand jury proceedings. We as defense attorneys vehemently oppose that position because we say it doesn't make sense to allow a charge to be brought forth on evidence that could potentially end up being the subject of a motion to suppress and grant it, and then it's thrown out at that later period of time. So it is, exclusionary rule does apply in criminal cases, but not at the grand jury stage, but not one of our favorite cases. Extradition, what that means basically is a person commits an offense in another jurisdiction, they leave, go to another place, and so the jurisdiction where they go to, the party is then sent back to stand trial. And there's what we call the Uniform Criminal Extradition Law, which the states and pretty much all jurisdictions allow for individuals to be surrendered to another jurisdiction. There's also some international ones where there are treaties between countries, but the United States does not have extradition treaties with all countries. Okay, so like Russia and some of those countries. The European Union has reportedly refused to extradite a person who would face a death penalty in the United States. So therefore, they don't have to do it. And so it is an issue because if they don't believe in the death penalty, they're not going to be required to extradite an individual. Joinder and severance of parties. Now, let me explain this. This is very simple. It can be complicated. When I was in law school, we went through several weeks trying to get this concept, but reducing it down to this most simplest form, what it simply means is that there's joint trials and then there's separate trials. For example, let's say two individuals are charged together, all right? But a separate trial will be required when the prosecution uses evidence against one defendant and has no relevance to the other defendant. It has happened in many cases where they are charged with different things, and therefore an attorney can move to have a separate trial. Or if there would be prejudice against one defendant based on evidence of another defendant, the trier of fact, which would generally be the jury or the judge. Defendants have inconsistent defenses. That is, they have defenses that may conflict with each other, and one defendant will testify, but the other is not. Definitely a separate trial. So it makes sense in terms of that. Joint trials, each defendant must receive a fair determination of guilt or innocence. But if you have any of those elements I just pointed out above here, these four, then there is a separate trial. Okay, and that's basically what it amounts to. Makes sense when you really stop to think about it. The Bruton motion is the motion that's filed where if a person is going to testify against another to say that they must be tried separately, in this case, the Supreme Court held that if one defendant testifies and the other does not, the defendants have to be tried separately. Because the reason is because they don't want the evidence of a person, one testifying another, to be held against a person who does not effectively forcing them to testify, which is a violation of their the constitutional rights not to testify. So Bruton and Evans were tried jointly for armed postal robbery. At the trial, a witness testified that Evans confessed that he and Bruton had committed the robbery. The testimony was admissible for Evans. Remember, Evans confessed because Evans had confessed to the witness directly. the testimony was not admissible because it would be hearsay against Bruton. So Bruton did not confess to the crime, therefore entitled to a separate trial. Makes a whole lot of sense because you would effectively, again, prejudice the individual of one defendant based upon what another defendant does. The various pretrial motions are these. One of the ones that we generally file is a motion to dismiss. In other words, we're asking that the case be dismissed completely, and we present our motion. Motion to determine the competency of the individual to stand trial. And that usually gets to the issue of insanity, what we call diminished capacity. But insanity, or if an individual is a minor and the law applies there. So we'll file a motion to do this. Motion to suppress evidence. That means there's some evidence that was obtained by the prosecution that should not be allowed because it violates the Constitution. Motion to suppress confessions because they're not reliable, or either the person wasn't Mirandized, or admissions or other statements. Motion to suppress the pretrial identification. Let's say, for example, a lineup, or what we call a show up. A lineup is when you've seen people in maybe a police station or someplace where they're all lined up together, and maybe the lineup is suggestive or is not fair to the defendant. The show up is when an individual is brought back and the person sees them and they say, yeah, that's the individual. We'll argue against that. That's a pretrial identification issue. We have discovered, though, that eyewitness identification, for example, is one of the most unreliable forms of identification that's utilized. We have been able to establish as defense attorneys so many methods to impeach individuals based on that. If you saw the movie My Cousin Vinny, you saw instances where the woman couldn't see because of her glasses. You saw the situation where the person was cooking breakfast and they were cooking grits and stuff, and that their time that they had was very brief. In fact, when I was in law school, my law professor did an experiment to us, unknowing to us, in our criminal law class. He was lecturing us in the big hall, and there was about 50 of us sitting there, and all of a sudden, some guy ran into the room and grabbed his wallet that was sitting right there in front of him and took off. And we all were like, oh, no. And then the professor went along with it. And so then he said, okay, take out a piece of paper and write a description of that individual. And we had so many different descriptions that it was unbelievable. And that's the whole point in a nutshell. And it was a setup. And the professor would do that to all incoming freshmen. I don't know. Well, he passed away, but I don't know if other professors are doing it. If I was teaching it, I would do it, because to make the point and demonstrate the fact that pretrial identification is not very reliable. Motion to disclose identity of an informant. Usually the state wants to try to protect an informant for various reasons. We still file a motion to find out who they are. Motion to change venue because you can't get a fair trial in the area or location. Motion for continuance is a common motion because for whatever reasons we're not ready, or we're still seeking to get information about the case, or a myriad of reasons. But these are various motions that are filed by us as attorneys during the pretrial. Now, arraignment, I kind of talked about that. Plead guilty or not guilty. And that's pretty much it. I'm not going to go into the deals of Alfred pleas where, but guilty or not guilty is all you need to be aware of for purposes of this class. Now, this I want to take time to tell you. This shocks a lot of people, but it is absolutely true. The bullet point at the top with the first X says more than 90% of felony cases engage in plea bargaining. And plea bargaining is cutting a deal. And usually we come to the stage of plea bargaining after we've discovered filed our motions, that it appears that the prosecution has a really good case against our client, and we'll enter into what we call in our jurisdiction a 402 conference. That's the section of the statute in Illinois that applies to having conferences and initiating plea bargaining. Well, the defense and the prosecution, and then the court has to approve it. Now, plea bargaining is a necessary evil, and it says without plea bargaining, the system would collapse. And the reason is because individuals have a right to trial, and that also there's not enough judges, courtrooms, and the system is not capable of handling that many cases. So the cases that are played out are able to keep the system operating effectively. And it said it would collapse because there would be so many people being released by exercising their rights to a speedy trial that it would just not work. In the plea bargaining, it's a necessary thing. The state puts out the fact that they don't have to bring in witnesses. There's oftentimes cases, well, even capital cases, murder involved, where the individuals don't have to come in and testify and go through the grueling thing of testifying before a judge or a jury. And then the defense does not have to put on any evidence. And, you know, the only thing to be aware of is that there generally is, there's a plea of guilty entered, and then it goes into the sentencing stage, and from that particular point. But usually the deal involves an ideal expectation of what the person can end up getting as a possible sentence. So the judges participate. One of the criticisms is of plea bargaining is that the judge has the power to improperly influence a defendant to plead guilty, put pressure on him. I had a young man that I represented one time who committed a heinous crime, and after all of my motions, exhausting all of my motions, I entered into a pretrial conference with the prosecution, and the judge came back, and the prosecution agreed that my client would be sentenced to a period of years, and they gave him the number of years. But because when he committed the offense he was a minor, they couldn't give him a death penalty. This was while we still had the death penalty in Illinois. We don't have it anymore, but let's, for purposes of discussion, that we had a death penalty. So he committed the offense at 17. So the judge said to me, tell your client that if he does not plead guilty and if he is found guilty, my sentence will be natural life. And natural life meant what it said. So I went back and, you know, ran the deal by him and his mom, and he decided otherwise against my judgment. I had it written down, made him sign that I had let him know of that. And so anyway, the point of the matter is that some could say, well, the judge gave an ultimatum. No, the judge just told the truth. And so the bottom line is that generally judges don't hold the power. They do make some suggestions. Some other criticisms is that it reduces the charges and punishment. Of course it's going to do that. There's no reason for a person to plead if they don't get something for it. Deprives clients of a fair trial. Again, it gets to the point that those of us who are very well prepared lawyers, experienced lawyers, and are familiar with the processes, we recognize that, you know, it looks pretty bad for the client. So what we do is to cut our losses and to help the client out. We will accept a plea and do it. There are some people who, again, think that the only people who plead people guilty are the public defenders. That is not true. A good lawyer will use the plea bargaining when it's necessary, and I never used plea bargaining unless it became absolutely necessary. But again, back to the original statement, more than 90% of the felony cases are done away with through plea bargaining. That means only 10% go to trial. So the United States Supreme Court held in the Borden-Hersher versus Hayes case in 1978, which was the year I came out of law school, that defendant cannot be punished for refusing to plead guilty and choosing to go to trial. So this person was charged with uttering a forged document. In other words, he made some changes to a document, forged it. The prosecution threatened to re-indict him on more serious charges if he did not plead guilty. He decided to go to trial. The prosecutor re-indicted him under the habitual offender law and was sentenced to life. The Supreme Court stated that this is a violation of due process because of the fact that they were twisting his arm to do so, and that was not good. And the Supreme Court says you can't do that to a person. Prosecutors have wide discretion. I already said that, whether to bring charges and what pleas to accept. While judges now they have mandatory sentencing, the prosecution discretion still is not limited because they can reduce the charges. This is a fact that minorities are more likely to be prosecuted and convicted of serious crimes than whites. That's a statement that's been proven by the statistics. Now, there was what we call determinate sentencing. I participated in 1978, 77, 78 when I was in law school at Northwestern in House Bill 1500 as my senior research project working with legislators. And Illinois went from indeterminate sentencing, where we had a wide range of sentencing, more toward determinate sentencing. And what that meant is that if you committed an offense, there was a range, but we knew within that range what you could possibly get. Before, it was so wide open that the discretion of the prosecution and the judges was way, way out there. So the determinate sentencing reduced the discretion of the judges and the prosecution, and we had an idea more about what a person could be charged with. Now, once again, they still could reduce the charges, but if the charges weren't reduced, then the sentences were already known. So, all right. Pretrial discovery, we've already been talking about that the whole time here, is the process which defense and prosecution interrogate witnesses for preparing trial. In other words, you can question the witnesses on both sides. Whether defense and prosecution can question witnesses. Now, the one witness they can't testify, the defense, or rather, prosecution can't question is the defendant for obvious reasons. Enhances the fairness of the trial, and then if the prosecution has some evidence that is exculpatory, in other words, information that would benefit the defense of their client, then the defendant must request it. You should be aware that in our motions for discovery, we have what we call a boilerplate form. It's a standard form that asks for everything under the sun, including any exculpatory evidence. So therefore, that satisfies that requirement. So if the prosecution has something like that, then they are obligated to turn it over. If the defense doesn't know about it, well, defense generally doesn't know about it. But anyway, the prosecution can't withhold it. If so, it could be a mistrial. Prosecution may not knowingly allow also perjured testimony. Okay. In federal court, it's different from state court. The Jenks Act and Jenks versus United States is more limited in the state courts. Evidence given by a witness cannot be viewed before the witness has testified. So it's a little more limited in terms of discovery. But there is what we call in-camera inspection, where the judge can review documents in their chambers and determine whether they're relevant to the subject matter. So I didn't do very many federal court cases, but I observed them. But I did notice that when you were tried in federal court as a defendant, it was tougher to um, to prepare a defense for a client. But those attorneys that I worked with and I knew and respected very well, who did federal cases, they knew very well how to get around this issue. I spent little time doing it. My deal in state courts is not limited at all. You can find out what statements and what information that a witness is going to present before they testify. Speedy trial, we talked about that. No specified time, but the 6th and the 14th Amendment says that the individual is entitled to a speedy trial. The 6th Amendment of the United States Constitution, as applied to the states through the 14th Amendment, says that, for example, with the 1974 Act, indictments must be within 30 days of arrest, trial within 70 days of the indictment. Defendant can file a motion to dismiss if the time limits are violated. Exceptions is that if the defense asks for a continuance and the time stops. But states have various rules that 120 days, for example, was what we had in Illinois, and those 120 days could last a year because of the fact that motions are filed to stop while discovery is going on. It takes more than 120 days to complete discovery. That's only 4 months. That's only 4 months. But the fact of the matter is that an individual has a right. You should be aware that all attorneys keep a little checklist in their files as to how many days have been used, and particularly with the prosecution, because if it goes past whatever the jurisdiction has for speedy trial, then the attorney can make a motion to dismiss the charges because the time limit has passed, and the judges will have to grant it without hesitation. Examples of speedy trials. What constitutes a speedy trial, as I say, varies across states. They have in common what is not clearly defined, but so it depends. And the speedy trial, in the opinions of many people, is not what the law says. It's statutory. It's pretty much what the statute says. And so that's it for that. Now let's jump into, so now we've gone through pretrial. This is what can happen with 90% of the cases. So now let's go into what happens with the 10% of the cases that actually do end up going to trial. That's what Chapter 18 is all about. And it starts out with the statement that you already know. Less than 10% go to trial. And they already said this. And there are generally two ways that cases are tried in our jurisdiction: trial by jury, which can range from 6 to 12, but in felony cases it's absolutely 12, or you have 14, you have 2 alternate jurors and so forth. But 12 is who hears the case. The jury then selects a 4-person and determines, they listen to the evidence. Going back to the Magna Carta, the law, and is formulated and transferred over to our current law, is that trials are conducted by juries of the peers of the individuals. Juries are supposed to have no knowledge of the case in our situation, the way the law operates now, fair and impartial. Now, the 6th Amendment has, as I talked about, the right to a speedy trial and a public trial. Voir dire proceedings. What is voir dire? Voir dire means to seek the truth. And what we do in voir dire is we determine by asking a series of questions of individuals who have been subjected to sit as jurors or subpoenaed to come to serve jury duty, to determine whether or not they're fit for our case. So we as lawyers have what we call challenges for cause. That means we don't have to have a reason for that person to be discharged. For example, they might admit that they're biased, or something like that. But generally, we have to use what we call a peremptory challenge, and jurisdictions give you so many. And once you use those, then you are out. You have to look for cause. Now, you can't use peremptory challenges, or should not be used, to discriminate against individuals based on race. Anyway, jurors are supposed to be impartial. They are informed of the accusations or charges. The witnesses will be there, and then counsel, of course. Now, an individual can represent themselves with or without standby counsel. What is standby counsel? Standby counsel is in cases where there are some people who decide for whatever reasons, and usually they're pretty out there, that they will not, they don't need a lawyer, they can represent themselves. But we have an old adage that he or she represents themselves has a fool for a client. But they will end up doing that, and so it creates an instance where they can do. And so standby counsel is where there's a counsel that's appointed by the court to be there to help those individuals. You have a right to an impartial jury. We already talked about that. In 2003, in the Scott Peterson case, this person was arrested for killing his wife and unborn child, and he was sentenced to death. The case received national coverage and was widely reported. Well, the judge changed the venue to Redwood City instead of Modesto, where he lived. But in his appeal, he argued that the change of venue still was not adequate because of the extensive media coverage. So the question is the media coverage. Well, here's the deal, is that individuals generally as jurors are sequestered, which meant that they are kept out of hearing the evidence as it's presented in the media and the newspapers and so forth and so on. So that's how most high-profile cases are dealt with, even some that are not high-profile cases. So we try to do the best we can to keep the individual from listening to media reports and other things that are not related to the evidence that is presented in the courtroom. Trial by jury is a right that you have, and the attorneys, we recommend to our clients. I generally recommended trial by jury. I love juries. I was pretty good with juries. And the jury decides versus the one judge. The right to a jury does not involve or take place in juvenile court. That's the one place it does not. But in adult courts, it does. The right applies to cases where the punishment is more than 6 months. And an offender, so that means it even applies in misdemeanors. An offender with multiple petty offenses is not entitled to a trial by jury. That's sentences where the possible charges where the person probably will have a fine as opposed to going to jail. But states have various rules. For example, Florida includes right for jury trial for all mala in se offenses. That is, all offenses where it's the state just has to prove that you violated, such as even strict liability laws. Jury selection, as I said, generally requires 12 jurors. Some states use a minimum of 6, but usually 12 is the ones that I've seen. 18 years or over, registered voters, and then there's the Jury Selection Act, which randomly selects jury panels in federal courts. Compensation is extremely small. In state court, I think it's like $14 a day, something like that. In federal court, I'm told that it's like $30 or $40, so it's more there. The fact of the matter is that that's all they have to pay you. And so it is a requirement that if you are served with, I just recently here in Illinois, we had a really interesting situation in the state court where President Obama just recently in the past month or so was subpoenaed and had to go to jury duty. and it was one of the most publicized situations. You saw it on the news. He was shaking hands and everything. Of course, his group, it never did make it to the courtroom, so they didn't use them. So it's our jurisdiction has a 1 day that you can go home if you're not picked. But let's say, for example, if he was picked to go into the courtroom, that would have been a very interesting scenario, but it never really happened. I have never been on a jury. I don't get picked. I have to go. I've had to go to jury duty. I've got my little 14 bucks, but the reason I haven't is because of my experience, my expertise. Judges, lawyers, they're all now subject to being subpoenaed for jury duty. It used to be that we could write a letter and get out. Not like that anymore. But I'd like to have served on the jury. I had someone I was just recently talking to on Facebook, one of my friends I grew up with, and she was on a jury, and she was talking about the experience. And then I had a colleague who works with me at the Romeoville campus, and she was on a jury, and she talked to me about the case after the case was over. She couldn't talk to me about it before, and about the experiences. And then one other thing I'll tell you about juries is that my daughter, which to this day I still don't understand how she was selected in a criminal case, knowing what I do, and then knowing what you know about me with my parents being killed and murdered. I'm surprised they picked her, but they did, and she became the foreperson. They elected her to lead the jury in the jury room, and guess what? The verdict, the vote for finding the person guilty was 11-1. She hung the jury, and she refused to change her position because in a criminal case, it has to be unanimous, not by a majority, as in the grand jury. So, long story on that one though is that they retried the young man with another jury, and he was acquitted. So she came back and said, "See, I was right." So anyway, it's a very interesting system. Maybe one day I'll get selected, but I doubt it. Avoid dire, I already told you, it means speak the truth. And when it's a selection of the jury, and it also is another way it's used too, but that has to do with motions at trial. But anyway, that has to do with determining whether a person, an expert witness, meets the criteria to testify as an expert. But anyway, voir dire for purposes here is to speak the truth. The goal is to obtain a fair verdict. And I already talked to you about challenges for cause, and I talked to you about peremptory challenges a little earlier. In Baston versus Kentucky, the Supreme Court held that jurors may not be excluded from juries based on their race. Baston, an African American, was tried for burglary and received stolen goods. The prosecution struck all 4 African American jurors using their peremptory challenge. The court saw a pattern and said that Baston did not receive a fair trial because it was clear what they were doing. So it's pretty clear that there is a requirement that you're tried by a jury of your peers. But there is a question that's still open before the court. There's some state cases that have been involved, and it kind of goes to the issue of your discussion post this week, where the defendant was white and argued that he was being discriminated against because no blacks had been selected for the jury. And so there's arguments that could be made, but there has to be a requirement in order for an individual to be able to bring forth those that defense, and they have to have something that we call standing, S-T-A-N-D-I-N-G, and there are cases to that effect, and it is something that I don't think that Danny has standing, and so as a result, there's a possibility that there was no discrimination against him. Now, there is still a possibility that there is, but here's the reason why I say that. It's because it hasn't gone to the Supreme Court as of right now. And one day, maybe it will end up, and then we can get a definitive answer. But for practical purposes right now, some of the case law that I've looked at say that, in this case, Danny didn't have standing. So anyway, that's that. Capital cases, there's what we call a bifurcated process, in which the trial is first determined whether or not that person is guilty, and then there is a separate hearing to determine the death penalty. Now, in the selection of jurors, one of the issues, if there is a capital case, in other words, one where there's a probable sentence of, or possible sentence of death, the jurors have to be voir dire on that question. Jurors who oppose the death penalty, who have scruples returning a verdict of jury, can be excluded from the jury for obvious reasons. Witherspoon versus Illinois, a 1968 case, an opponents of capital punishment should only be excluded if they could not make an impartial decision. So the question is, would you be able to be fair, or would you just say no, straight to the death penalty? And in that case, then, Witherspoon would be satisfied. Wainwright versus Witt, 1985, a later case, exclusion if the juror would prevent or substantially impair the performance of their duties as a juror in accordance with the instructions. In other words, that they wouldn't care what the instructions say, they already decided what they want to do. Then that person is gone. Rivera versus Illinois, the Supreme Court held that a trial judge's erroneous denial of a defendant's peremptory challenge did not constitute an error sufficient. And the reason why, Rivera's attorney submitted a challenge for a juror, but the challenge was denied by the judge. Well, the court held that this was what we call harmless error. In other words, that the error did not really impact the outcome of the verdict. We as lawyers, defense lawyers, don't even agree with that concept of harmless error. We believe that if it's error, it's potentially harmful, should I say. But it is a concept that we still have to deal with. We still argue for the record our position on it, but then that's setting the record for appeal. We already talked about this kind of, the sequestering of jurors, like in the O.J. Simpson case. They were protected against outside influence. That's kind of like what we talked about in the Scott Peterson case. The press, for example, and the First Amendment. This is changing. Cameras are allowed in some states. More and more states are allowing cameras. You recall, and I did, the entire O.J. Simpson case was completely covered by cameras, and they were allowed in the courtrooms. Then there are what we call, and it's coming more and more in many, many states since that time. That's what you hear a lot of time when you see court TV. You see actual cases that cameras are allowed. We're gradually getting to that stage in Illinois. Gag orders. This is an order where the judge says nobody talks to the media or anybody else about the case. Prohibits attorneys, witnesses, jurors, and others from talking to the press primarily. To not, and you could get sanctioned for violating that, and you could be found in contempt of court. Again, the bottom line is trying to protect and preserve the right to a fair trial for the defendant. Shepard versus Maxwell, they actually did a movie about this, and it was based upon this Dr. Shepard. The Supreme Court held that intense media coverage may prejudice the jury and violate due process rights of a defendant. Dr. Shepard was convicted of murdering his wife, and the jury was greatly influenced by intense media coverage. The court overturned the conviction. Shepard was found not guilty on retrial. They tried him again. His son filed a civil suit against the state of Ohio, claiming that his father was wrongfully incarcerated, but the claim was rejected by the jury. So the point of the matter is that in cases where it's excessive. And boy, if you saw how that was, I mean, it was like the media was camped out, and the jurors were able to see this. They were not sequestered, and after that, sequestering became very strong after that to protect it. But Sam Shepard's case did turn out that he was found not guilty. Nebraska Association versus Stewart, in which the Supreme Court said that a gag order is to protect the fairness of the trial. And so the court entered a gag order where the defendant was charged with 6 murders and a sexual assault. And the trial received a lot of attention in the news media, and so the judge issued a gag order to prevent undue influence. And the newspaper or the press appealed, saying that it was a violation of the First Amendment. The court says no, because it is paramount to protect the individual rights to a fair trial. What do the judges do? They control the court, they control unruly defendants, they issue contempt orders. Counsel have to follow the rules and ethics of the courtroom, not supposed to express personal opinion or inflame the jury. Judges, and there's a thin line between that, and if judges find that a lawyer has done it, they can recommend reprimand and a possible referral to the Bar Association. The bottom line is that, again, trying to keep the right of the defendant to a fair trial in order, intact. The rules of evidence. Rules of evidence is a process that all the evidence is something that takes place in the courtroom. Everything that comes across in the courtroom, exhibits, testimony, but not opening and not closing statements. But evidence can be verbal, in writing, documents, pictures, tangible items that prove or disprove. Now we got the DNA, which is the great thing that came about that didn't exist when as I was retiring, it was coming in. But when I started out, we didn't have any of that. In fact, we had no technology at all. Judicial notice, where the judge can take note of things. Proof is beyond a reasonable doubt. Evidence must be relevant to the actual charges or the point that you're trying to prove, which must still be relevant to the charges. There's some exceptions. There's what we call, the federal rules of evidence came out, and then most states adopted them, and they have what we call exceptions to evidence, which is hearsay. Hearsay is generally not allowed, but in the instance of the rules of evidence, then they are allowed. I won't go into that. There's a course I teach on that where it's called Evidence, and it's a great course, and I love teaching it, and we discuss some exceptions. Similar fact evidence refers to evidence of a fact similar to the facts that are like the crime. Prior crimes may be admitted. Be aware of the fact that an individual who does not testify, you cannot bring back in their background. But if they testify, that evidence of prior crimes can be used to impeach them. There's classification of evidence. That's what we call real evidence. That's something you can put your hand on. Direct evidence that goes directly to the charges. Indirect evidence, which leads inferences. Eyewitness testimony, we already talked about that. And then circumstantial evidence, which is something that kind of helps make the charges more plausible and lean towards the likelihood that the individual did commit the offense there. So, whoops, I don't know what I did. I hit something. I gotta go back. Okay, let's go back to. Okay. Okay, let's go back to this. Let's go back to, okay. I don't know what I hit. Okay, I got thumbnail view. Anyway, Those are the bits of evidence there. So then we got expert witnesses. I kind of talked about that a little bit earlier. And whoops, I lost my thing there. Let's go back to it. There we go. And these are types of expert witnesses: forensic evidence, medical experts, handwriting experts, and then we can cross-examine them. Hypothetical questions are allowed to be asked of those witnesses. Okay. And expert witnesses, there's some examples of experts, and those individuals are then allowed to testify as well. So, all right, there we go. We're back to where we were. So let's go back to that. Okay. So anyway, these are some examples of experts. In Texas, one of the most important questions juries have to answer about defendants is their ability to be dangerous in the future. Juries who believe the defendant is a future danger would typically impose a death penalty. And this is something we don't deal with except in Texas. Scientific evidence is admissible. I already talked about the fact these are different scientific evidence, that polygraph tests, but DNA is now the most revolutionary change to trials now. It eliminates and proves the innocence of a lot of different people. So technology has also made it better to prepare a defense. Okay. Objections. Objections in court, for example, you hear a lawyer say, objection. There's what we call general objections, where we just say objection. That'll be against the witness or a testimony, and the judge won't. But then there's what we call specific objections, such as hearsay. I already talked about that, where I'll object, and the judge says, objection, and then I'll say hearsay. In other words, that the witness is about to testify to something that they heard from somebody else, and it does not fit in one of the exceptions of the hearsay rule. The best evidence, in other words, evidence that's being proposed, there's better evidence, and the judge will allow an objection saying that there's better evidence. Calls for an opinion. The witness must not be allowed to give an opinion unless they're an expert, and then you're dealing with a hypothetical. Just about done here. Crawford versus Washington, the Supreme Court held that in all criminal prosecutions, the accused has the right to confront witnesses against them. In Crawford, the prosecution introduced a recorded statement from his wife in which she stated he did not act in self-defense. Crawford appealed, saying that the pre-recorded statement violated his right to confront witnesses against him. And that's what I'm talking about there. You have to be able to cross-examine the witnesses. There's privileges, such as the attorney-client privileges, which means statements that are made by a defendant to the attorney. The attorney cannot pass that information on. It lives as long as the person lives. If the client passed away, then it's no longer in existence, obviously, for obvious reasons. You can't do anything to them. But the client can also waive the privilege. Another way of waiving it is if someone is in there that has nothing to do with the case. For example, working maybe as a paralegal, that's fine. But let's say someone else, a friend, is in there, that's different. Marital privileges, we don't want to have a wife to testify against her husband and vice versa. Clergy, priests, ministers, rabbis, there are some limitations to that, but that privilege exists. And same thing with doctor and patient privileges as well. So in the criminal trial, the judge already serves as an umpire. They rule on motions. They instruct the jury. They have a lot of discretion, but then you can appeal their decisions in the appellate court. Opening statements, each side has a chance to present their theories of the case, and then defense can defer an opening statement. However, though, the defendant doesn't get the last word because the burden stays with the prosecution. The prosecution can call witnesses, lay witnesses versus experts. Experts, I already laid out the foundation for what expert witnesses can and cannot do. They can be asked hypothetical questions. Lay witnesses, you cannot do that. There's a right to confrontation and cross-examination of all witnesses. The Sixth Amendment guarantees that. You cross-examine by asking what we call leading questions. In other words, you can suggest answers by the questions that you ask them. For example, isn't it true that blah, 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 blah? That's the leading question. You can't do that on direct, but you can do that on cross-examination. Witnesses are subject to impeachment, which means that there can be something that could be presented that discredits their testimony. Child shield statutes protect children in terms of cross-examination and things of that nature. Same thing with rape shield. We already talked about that before. Protects individuals from being asked certain questions as well. Defense moves for the judgment of acquittal. We say that there's not enough evidence and that we ask the clients be dismissed. That's the judge will then rule on that. Defendant has a choice to take the stand. It is something that I've had clients to do, and then there are times when I did not, because I knew my client would get eaten alive, or I knew that they had a prior. So the prosecution can cross-examine that defendant and bring up priors. That means prior offenses that the person has been involved in. Rebuttal witnesses. I had a case where I had it completely won, and then at the end, the state asked for the right to present a rebuttal witness. The rebuttal witness came in the next day and shot my whole case out of the water because it was a person that had some information that they withheld to the very end, and my client was found guilty. So that could be done. The jury should listen to the evidence. Judge can allow questions for witnesses. And then there's the closing arguments where both sides presents their summary of the cases. Again, the prosecution speaks first, the defense speaks second, and then the prosecution speaks last. Jury instructions are some legal terms that are provided to the jurors, and they actually give these to them. They explain them, and then they give them copies, and they can take them into the jury room to explain possible defenses. The judge does not summarize the evidence or give any opinion in the case, but just gives the instructions of the law, and that's it. And then the jury makes a decision. I'm told from talking to jurors that they listen to it, but they pretty much focus more on the evidence that comes across in the courtroom itself. Okay, we're just about done here. Jury then deliberates. They select a foreperson, and then their room is secret. There could be sequestered. I said that already. A deadlocked jury, a jury that cannot agree on a verdict, there's an Allen charge. What that means is the judge can ask them how close they are, and they can determine. Of course, if it's determined that they, after going a period of time, they're deadlocked, then they're brought out, and then the jurors are asked if that's their vote, each and every one of them, whatever their vote is, and then if it's not a majority, if it's not a unanimous, then the jury is hung or deadlocked, and then the charges are not dismissed, but there's declare a mistrial. And then the prosecution then will have the determination, not right then and there, to decide whether they're going to retry that person or not. Jury pardons, which means some jurors were on the jury for the wrong reasons, and so they messed up the jury. Jury finds defendant not guilty, despite the evidence, and that happens sometimes, but not very often, that the judges interfere in that. O.J. Simpson case, they talked about that as an example. The jurors were sequestered for 9 months. They couldn't, and then these are all the limitations they could not do. They couldn't lock their rooms. They couldn't telephone without a deputy present. They ate cafeteria style. They weren't allowed to watch TV programs unless they were pre-approved, and could only see family in the presence of deputies. Once again, the point of the matter was to protect them from hearing evidence that might tamper with their being fair jurors. And then the last thing is that the verdict is written, and then the judges, what we call poll the jury, ask each and every juror, is this your verdict? I was talking about that earlier. And then at that time, if the person is found not guilty, then the person is released. But if they are found guilty, then post-trial motions. A motion for a new trial is requested, alleging that errors were committed at trial, and it's usually denied, but this is for the record. And then the individual has a right to file a notice of appeal, which then begins the process for appeal for the charges. Okay, so that's that. And so I have nothing else to add. I hope that this has been beneficial and helpful to you. And again, I hope that I wish you each the best. Next week is the final week, and make sure that you continue to get your assignments in. If you have any further questions, you know how to reach me. You know the rules about how to reach me, and some of you have done that. So with that, I'm going to say good night.